Good afternoon, everyone, and welcome to our webinar on social media in the workplace. Thank you for joining us. My name is Donna Marie Parash, and I am your moderator for today. I am joined by Lewis Izzo, Director for Australian Business Lawyers and Advisors, and Kyle Scott, Senior Associate for Australian Business Lawyers and Advisors. Thank you both for being here today. If you have any questions during the webinar, please submit these via the chat box on the bottom left-hand side of your screen. You will see a small grey cogwheel settings icon, and you can enter your messages to the right of it in the white box. We will endeavour to answer as many questions as possible throughout the presentation, and remaining questions will be answered at the end of the presentation. I will now hand over to Kyle and Lewis.
Thanks, Donna. Hi, Lewis. Hi, everyone. Thanks for joining us for today's webinar on social media in the workplace. All right, so today's webinar we will address, I think, 7 common workplace issues, and we will also look at a number of case studies and help try and provide some guidance for HR managers how to grapple with those common workplace issues. We'll then look at social media policies and finish with some practical tips.
Thanks, Kyle. Hi, everyone. In relation to common workplace issues, there's really 7 different types of things we're going to look at, and you'll see them up there on the slide. But they're really kind of broadly categorized into 2 sections. One is the activities of employees during work, so what they actually do in the workplace and what employers can and can't do and shouldn't do to manage those types of behaviours. And then there's a second category, and what's becoming kind of more and more of a hot topic, and that's what happens outside of the workplace. So when you have employees engaging in social media activities outside of work, to what extent can the employer's reach extend into those areas of life which traditionally people may have considered to be an employee's private life? To what extent can they be held to account for what they do outside of work? And as you can see, there's a number of different types of areas we're going to look at in exploring that topic. So that's essentially the core focus of what we're going to be talking about in relation to social media's common workplace issues. That'll take up the majority of our time, and as Kyle said, we'll deal with the media policies at the end.
So we'll just start by having a look at a few of the stats. Workplace Info did quite a comprehensive survey earlier this year and released a white paper, and you can see there on the slide that bullying through social media is occurring in 23% of businesses. 43% of employers monitor employees' usage of social media, but only 40% of employers have social media policies. And then lastly, social media sites are being used by recruiters 59% of the time. So that is having a look at candidates' LinkedIn pages or Facebook pages when determining whether or not to recruit that person. So I think the takeaway there is that social media is here, it's here to stay, it is an issue, and so HR managers need to put in place policies and systems, firstly to try and prevent issues arising, and then secondly to try and deal with those problems when they do arise. All right, so if we move on to the first common workplace issue, and that is employee usage during working hours. It should be pretty straightforward that employers have the right to regulate employees' behaviour while they're at work during working hours, and that excessive social media usage while they're at work may well interfere with the employee's productivity or output, and where that does arise, that should be treated as a performance issue. So hopefully you have some systems in place to deal with those types of performance issues, whether it be through informal counselling, elevating that to written warnings or verbal warnings. Hopefully you don't get to it, but you might in some cases then need to put in place some kind of performance management. It should also be noted that given that it's the employer's IT system that might be being utilised during working hours, it's your property, so you can restrict or block an employee's access to particular websites while they're at work.
Just in relation to that, something that the employers also need to be conscious of when you're dealing with monitoring employee usage at work is just that in New South Wales we have the Workplace Surveillance Act. There's similar legislation now in place in the ACT, which actually imposes a number of obligations on employers in respect of notifying employees about usage and things like that. So it's important that that employers ensure they comply with those requirements, because what you don't want is to end up in a situation where you have you've monitored, you've found something in relation to some misbehaviour, but then you can't use it down the track because you haven't complied with the legislative provisions. So that's just something to bear in mind.
Yeah, that's a good point, and that's one we'll touch on in a bit more detail. In terms of excessive usage, there is a case from 2011, an unfair dismissal case, so it's now 5 years old, but it really just demonstrates that excessive use of social media may constitute a valid reason for the dismissal. You can see there the facts were that the employee was sitting at work engaging in Google Mail chats with his friends. He engaged in 3,000 chats over a 3-month period. The employer found out about that and unsurprisingly wasn't very happy and dismissed the employee. Now, there were procedural deficiencies in the process there, so the result was that the Fair Work Commission found that the dismissal was unfair, but you can see there quite clearly the observation by the Fair Work Commission, that is, where there is excessive use of social media, it may constitute a valid reason for dismissal. Alright, so the second common issue, which is what Lewis was just referring to, was monitoring employee usage. So there is workplace surveillance legislation in most states and territories which put in place some requirements about how you lawfully do that. In New South Wales, it's unlawful to monitor employees' usage of IT or GPS tracking or things of that nature, unless you tick the boxes that are contained within that legislation. That includes giving 14 days written notice, telling employees what type of surveillance you're proposing to do, how long that surveillance will occur. So that includes computer surveillance, which is relevant to social media, but it also includes other tracking or other surveillance, including CCTV surveillance in the workplace, and if you've got sales reps with company vehicles, whether you might have GPS tracking devices. And you also see these days more and more GPS tracking in company mobile phones. So there is legislation in place in different states and territories that you should be aware of. And the case study here relates to Australia Post. And this really shows, I should go back a slide, sorry. You can see there down the bottom underlined, you should be enforcing the policy. So if you do have a policy about employees' use of the IT system, it is important to enforce that policy consistently. And this case study shows what happens when you have a really inconsistent approach to dealing with these issues. So Australia Post 2013, I should take a step back. I think in around 2010, Australia Post decided to implement some IT monitoring. Previously, they had a fairly relaxed approach to IT monitoring, but in 2010, they implemented some IT monitoring technology. They then discovered that a large number of their employees were sending inappropriate things back and forth, and I think about 40 employees were involved, and it resulted in 3 of those employees being terminated. The other 37 presumably were counselled or received warnings. Those 3 employees then brought an unfair dismissal claim, and at first instance the Fair Work Commission found that the dismissal was fair, that they'd circulated pornographic material, it was inappropriate, they were in breach of the policy that came in 2010, and therefore the dismissal was upheld. Those employees then appealed that decision to the full bench of the Fair Work Commission, and the full bench found that, notwithstanding that their conduct was inappropriate and that it breached the policy, they found that because there was a historical absence of monitoring and enforcing the policy since it came in 2010, there was a really inconsistent approach to this. There was a culture where most managers knew it was happening and weren't enforcing the policy. They found that in those circumstances the dismissal was unfair, and those 3 employees were reinstated to Australia Post.
So now we're going to look at the blurred line between work and private life. So this is where things start to get particularly interesting, and we talk about what happens outside of the workplace. And I thought perhaps a helpful way of dealing with this issue was to take everyone back to what is probably the seminal case in this area. Whenever we talk about conduct outside the workplace, and it doesn't matter if we're talking about social media or if we're talking about behaviour at a Christmas party, behaviour on the weekend at the pub, it's the same principles that apply, and they all really derive from a case that was decided back in 1998, which is called Rose and Telstra. And what happened in Rose and Telstra is that we had a situation where a Telstra employee, Mr. Rose, went down to Armidale in order to perform some additional field service type communications work because there had been a number of outages in that area. So he left his normal area of work and he goes down to Armidale. And he gets down to the area where he's meant to be working, and his manager informs him that another employee, Mr. Mitchell, is already here and that if they like they can share the same hotel room. That's not a problem. Mr. Rose thinks that's great. I'll do that. So he knows Mr. Mitchell well and agrees to share the hotel room with him. So they're down there on a Friday night, and they've effectively finished working for the day, and they do what people might tend to do on a Friday night. They go have a few drinks. Not only do they do that, but they decided to then go out to a nightclub. The judgment refers to the fact that they were drinking quite heavily at the nightclub. Mr. Rose's evidence was something to the effect that he'd had a few beers and 4 or 5 or 6 or 7 bourbon and cokes or something to that effect. So he'd had a bit to drink. And what happened is the night went on, the relationship between the two deteriorated to a certain extent. They ended up in a bit of a disagreement. And they ended up going back to the hotel room separately. Mr. Mitchell gets back to the room first, I think, but then Mr. Rose ends up arriving at the hotel room. He opens the door and he effectively confronts his colleague, Mr. Mitchell, and says, look, if you want to have a go, let's have a fight, effectively. He starts, it's a little bit odd, but he starts rearranging the furniture inside the hotel room. So he's effectively set up the room like it's a boxing ring. And he's like, if you want to have a boxing fight, I'm here, let's go. To this point, Mr. Rose, even with all the bourbons inside of him, probably thinks he's got things relatively under control. What happens next, he probably didn't anticipate. Mr. Mitchell walks straight up to the hotel room window, punches his fist through the hotel room, and grabs a shard of glass and proceeds to stab Mr. Rose in the chest. Mr. Rose is left with what one could only describe as a wound. He's obviously been injured by the altercation. Ultimately, ambulance is called. Mr. Rose ends up with 12 stitches. Mr. Mitchell ends up with a malicious wounding charge, which ultimately ends up in four months in prison. And Mr. Rose ends up with his employment with Telstra being terminated. And it's terminated on account of his serious misconduct in engaging in violent behaviour outside of in this kind of situation. And Mr. Rose brought an unfair dismissal claim, and he sought to establish that the dismissal was unfair because it related to things that happened outside of work, and so he shouldn't have been held to account for that. And the member who heard it was Vice President Ross at the time, and the Vice President was a Vice President of the Australian Industrial Relations Commission, who's now in fact the President of the Fair Work Commission. And His Honour went through all these different factors. He considered the fact that they were being paid an on-call allowance at the time, but they weren't at work. They weren't in uniforms, nor on-call in the sense that they weren't actually on-call. Sorry, when I said on-call allowance, I paid a travelling allowance as opposed to on-call allowance. So they weren't on-call. They were engaged in activities in their private time, albeit that they were staying in accommodation provided for by Telstra. And His Honour ultimately concluded that there's really 3 things that one needs to look at before determining whether an employee can be disciplined for conduct outside of hours. And And those three things are as follows. Firstly, the starting point is that the employer doesn't have business interesting themselves in terms of what happens outside of work unless the conduct is such that it's likely to cause serious damage to the relationship between the employer and employee, or the conduct somehow damages the employer's interests, or it's somehow incompatible with the employee's duty as an employee. And what we ended up seeing is, and this has been referred to over and over again now in cases that have followed, is a rule, which you'll now see on the slide, the general rule, that you can't regulate out of hours conduct, but we need to find, if you're going to regulate it, some connection back to the workplace. Is it in connection with their employment? You'll see one of the bullet points there. Or has it had a significant and adverse effect on the workplace? And occasionally there is that other one, which is somehow it's just entirely incompatible with their duties as an employee. But you really need one of those connections to enable you to be able to monitor what's going on outside of work. Now, in this case, His Honour, now President Ross, found that on balance, there wasn't a sufficient connection to the workplace. Telstra pointed to the fact that the case made it into the local media and that there was some publicity in court on the Monday. They said that the employees were down there in that area for work-related reasons. Vice President Ross indicated, well, there's a whole range of other things that indicate to me that it was in their private time, not paid for by work, not doing anything related to work. And I think this case, the way I see it is, it probably sets what is that very thin grey line and sits right on it. I think to some people, it's a little bit of an interesting outcome, and to some you'll hear some, perhaps more employers than others, criticise the decision as perhaps being too lenient on the employee in question. Others think that, no, it's fair enough. And I think that's why it's quite a helpful case, because I think it probably sets the grey line, and it's right on the border of what should or shouldn't be able to be subject to disciplinary action from an employer. So that's kind of what happened in Telstra and Rose. The nature of the events is startling enough that it kind of always resonates in the memory, so it might be a helpful one to keep in mind. That's essentially the principle. When we then turn to look at its application to social media, as I said before, it influences the whole approach. So I think Kyle was going to now look at a specific type of behaviour, like criticising employers online.
Yeah, sure. Thanks, Lewis. So criticising employers online outside of working hours is one of those first. I'll go back a slide so you can see what I'm talking about, but you can see the exception there where the employee's conduct is in connection with the employment or has a significant and adverse effect. So criticising an employer online outside of working hours falls within that first exception, which is that it is in connection with the employment. You are criticising your employer, so there's a connection there. And all employees in Australia have in their employment contracts an implied duty of good faith and fidelity. So conduct where you are outside of working hours disparaging your employer will generally be a breach of those obligations of good faith. Again, it should be dealt with as a misconduct issue.
So am I still on? Yes, yeah. Seeing the case study light up, I'll jump into to get back into the storytelling.
Yeah, go for
it. In relation to trying to demonstrate how some of this works in practice, I think we've got two case study examples. The first, and I think Kyle found this with much elation just because of the circumstances involved, but the first relates to a restaurant manager who liked some complaints against the own restaurant that the restaurant manager worked at. So it's a bit of an odd one. I'm still trying to work out why it is exactly that you might want to start liking complaints against your own workplace. She also had a number of performance issues that were going awry, weekly stock takes, things like that. And so we ended up in a circumstance where she's done the wrong thing. She was ultimately dismissed, and the Commission upheld the dismissal as valid. And part of that relates to the fact that she's publicly endorsing what appeared to be criticisms of their business. Interestingly, the Commission made a bit of a side note about the fact that the restaurant manager liked the complaint doesn't necessarily mean that she set out to damage her employer's corporate reputation. Well, that might not be what she set out to do. But again, the question is objectively viewed. Is that a likely outcome of the conduct? And the Commission was satisfied that it was. So that's one example. The second example we have relates to Centrelink. And at Centrelink we had an employee with approximately 20 years service who was, I think, fair to say, a habitual user of online forums and general blog type forums, for want of a better word. He gave evidence in the proceedings that he has thousands of posts across all sorts of different forums. But in particular, he posted on two forums, one called Whirlpool and the other one called Sportal, in which he actually made some disparaging comments about clients of Centrelink. He referred to, as you'll see on the slide, to some Centrelink clients as spastics or whinging junkies. And he also managed to identify himself as a Centrelink employee because he talked about, in one of the examples, he talked about the timeframes for processing certain applications and made it evident that he was an Centrelink employee. In fact, to the point that someone asked on the forum, "Are you an employee of Centrelink?" And he said, yes, I am. He proudly announced he had 20 years service there. And then he goes on to talk about clients in such a disparaging way. Vice President Hatcher in this decision was satisfied that the conduct was such that it warranted disciplinary action. So because he had identified himself as an employee of Centrelink and because he had made disparaging remarks about Centrelink's clients, quite inflammatory, damaging remarks, that was something that the employer was able to discipline. And you'll see in the quote there that Vice President Hatcher said that it provided legitimate grounds to dismiss the officer for his posts. What the Vice President ultimately found was that the decision was harsh in all the circumstances, though, and that was primarily on account of the 20 years of service. And so he really balanced together the fact that this employee done the wrong thing, but you still, in any unfair dismissal, have to then consider the harshness of the decision or the ability of the harshness or generally the fairness of the outcome, and in that case found it was a little too harsh. But it doesn't detract from the fact that that type of behaviour and public posting of comments in forums was something the employer legitimately was able to take action about.
So we've actually had a question come through asking, what if an employee makes an inferred negative comment about their employer, so one that's not exactly direct, but they have it clearly indicated that their profile that they work for the employer?
Yeah, so that's a really good question. There's a number of things that we can say about that. Firstly, you need to have a look at the comment and see how serious the comment is, how damaging the comment is, and whether or not you can actually make a finding that it is a negative comment about the employer. The second thing is where they have indicated in their Facebook profile or whatever social media platform they're using that they're identifying who their employer is. Obviously, that then makes it easy to say, well, it's out of hours as a start, but there is a connection to the workplace because your comment, which could be read as disparaging your employer, combined with the fact that you have identified who your employer is, may well, that means that there is a connection there. We have the right to regulate that behaviour, and also the exposure to reputational damage exists because people reading that can identify who the employer is. But again, in terms of the seriousness, you'd have to see, well, what is the comment? How many people have viewed it? If it's a Facebook page where they have 20 friends and the security settings are fairly tight, while you might be able to regulate that kind of conduct, you're probably not going to be able to dismiss them because the damage really isn't that severe. So no two cases are the same. You really do just have to weigh up all of those facts. But certainly the exposure to reputational damage is greater where people can readily see who the employer is.
And Kyle, interestingly, we've just had another question come up, which is how do you deal with comments when the person's partner or family's made the comments and states that their partner works for the company? Well, you're really entering into a difficult area there, because at the end of the day, an employee can be held accountable for their behaviour by the employer, but it may not be, in many cases it won't be, available to an employer to discipline their employee for the conduct of someone associated with them, whether it's a relative or a friend. Now, if in the case, let's say it's their partner, someone's husband or wife, then if it happens once, that's the kind of thing it'd be very difficult to criticise the employee for. But what you'd be doing is making it very clear to the employee what the expectations of the company are. You'd be saying that you expect them to convey that to their partner. And if a pattern emerges, then all of a sudden it may be that you can start to say to the employee, well, clearly you're not conveying this message. Clearly there's an incompatibility here between your employment and your personal circumstances because of what's going on. But as a general rule, you'd need to be very careful before disciplining something for something that their family or a relative has said. You need to be very careful, because otherwise you may find yourself without a valid reason to base the disciplinary action on.
Yeah, that's a really difficult issue, and that's kind of the fine line between trying to legitimately regulate your employees' conduct and being conscious of ensuring that there's no reputational damage to the business. Balancing that against general notions of the ability to speak freely outside of work. So it is a real balancing act. I'm not sure that you can necessarily extend to an employee's family member doing something. That's probably going a little bit too far, but again, it just depends on the specific facts and circumstances. All right, so if we move on to the next topic, which is bullying, harassment and discrimination, we tend to see a lot of these types of scenarios where employees go onto Facebook or social media after hours and make disparaging comments about their supervisors typically, and sometimes other employees. My general rule, and what I like to say to clients, is that conduct and comments which are made online should be treated in the same way as if those comments were said to the person's face in the workplace. They should be treated in the same way. It shouldn't be the case that because it's somehow offline, at home, on the internet versus face to face, that it's somehow less serious, because that's just not the case, and the case law make that clear. The definitions in terms of what is bullying, harassment and discrimination are exactly the same. It doesn't matter. There's no two different tests for when you're online versus offline. Bullying, harassment and discrimination can take a wide range of forms online. The most obvious ones are typically people putting comments on Facebook about their boss, about another employee, uploading photos, videos. You do from time to time see people making fake profiles or fake accounts. And there was a recent decision of the Fair Work Commission in the bullying jurisdiction, where the commission member found that an employee who had unliked, or I think it's unliked a colleague on Facebook. So they were friends on Facebook, sorry, unfriended. So they were friends on Facebook, and they decided, this particular employee decided, I don't like that person anymore, I'm just going to not be friends with them anymore, so deleted them from their friends. Now, that wasn't in isolation, that was in the context of a range of other conduct, but the commission member specifically referred to that specific conduct and said, well, the reason she did it was because that she decided she didn't want to be friends anymore, and in the context of everything else, that did amount to bullying. If we have a look, we've got a couple of case studies on bullying and harassment online. They're both fairly serious forms of bullying, and in both of these unfair dismissal cases, it's quite surprising that the employee in the first instance actually decided to pursue an unfair dismissal after what they did. But both of these cases, the Fair Work Commission said, well, no, the employer was right and it was a valid. The Fair Work Commission said, well, no, the employer was right and it was a valid dismissal. I'm not going to read that first Facebook post, but you can see there that the Fair Work Commission, this case is a little bit old, now 5 years old, but they make it very clear that threatening another work employee is a serious issue, and one which would not be tolerated in any workplace. And there's the comment there, which you can see is about 5 years old, but this talks about the separation between home and work is now less pronounced than than what it used to be.
Yeah, and I think that's an interesting point.
Over the last 5 years,
the reality
has become
is
even
that
clearer.
With some of these older Facebook cases, or there was one involving Linfox about the same time, there was a little bit more leniency given to employees in around 2010 than there necessarily will be now. I think there is an expectation in the community, and certainly in the Commission, that people now should have a level of awareness that when they post things on people's walls, or they post things on a public forum or something like that, that their comments will be publicly known, they will be publicly read. And so the ability to say, oh, we weren't aware that it was going to be public, that's very difficult to make those types of comments now, and very difficult to try and justify one's behaviour in that way.
All right, I'll touch quickly on the second case study about bullying and harassment. You can see there's another Facebook post. Again, I'm not going to read that out. It's very offensive. The comment here was really interesting. So this is a 2013 case. The employer here did not have a social media policy, and the employees ran an unfair dismissal case saying, well, there wasn't a policy telling me what I could and couldn't do online. I didn't know that, I wasn't able to do that. You can see the comment there from the Fair Work Commission member. One hardly needs written policies or codes of conduct to understand and appreciate that the comments were grossly offensive and disgusting. So it's not the case that if you don't have a social media policy, you're somehow exposed to an automatic unfair dismissal, although the risk is greater, but there is some form of conduct for which common sense prevails. You don't need to have a policy or a code of conduct that says to the nth degree all the things that an employee shouldn't be doing. There is a degree of common sense that employees should have.
So we've actually had a comment come through, just to go back a little bit, asking for clarification that employers can't use mobile tracking on employees.
Yeah, with the tracking and with a lot of this, there's actually quite specific notice requirements. So what we'd recommend, because the Workplace Surveillance Act, it does depend which jurisdiction you're in, but generally it requires a whole range of different notice provisions to be given, as well as having information placed on, if you're tracking a vehicle or a mobile, you need an actual documentation, or you need a sticker or something placed on the device being tracked. So if you've got a specific query in relation to what you need to do on that front, I'd encourage you to get in contact with us, because it's quite prescriptive, the various notice requirements. It is 14 days what the notice is, but in addition to that, there's a fair few different steps. So I'd encourage you to kind of get in touch so we can make sure you're fully compliant.
Yeah, and there are different pieces of legislation in different states and territories. So if your business operates in more than one state, then it becomes slightly more complicated again. If you do engage in IT monitoring or GPS tracking or CCTV surveillance, you can deal with that in a number of ways. You can deal with that by having a clause in your employment contract. You should have a policy, and that policy can either form part of your social media policy, or it can be a standalone policy. All right, so just finalising the slides on bullying and harassment. Like most things, like most employee behaviour issues, once you determine that there is a connection to the workplace, if it's out of hours or there's some reputational damage there, you should be going through this checklist, if you like, assessing how serious was the conduct, who saw it. So if it's on social media, was it seen by thousands of people? Was it seen by 20 people? Of that audience, how many of those people who saw it were employees? Because that's relevant. You obviously want to have a look at whether there is a breach of your social media policy, and then you go down the typical disciplinary investigation path, and hopefully you again have some systems in place to deal with that. In determining whether or not you have the grounds to terminate an individual or other disciplinary issues, you want to be looking at, well, what is their performance record? have they expressed contrition or remorse for their conduct? Do they actually identify, oh yes, I did go too far, that was inappropriate, and I now see that? Or is it the case of saying, well, I can't see what the problem is, I don't know what all the fuss is about? You also want to take into account their length of employment, and those factors are things that the Fair Work Commission in any unfair dismissal will take into account. You then also, as part of the disciplinary process, you do need to be giving employees procedural fairness. So putting the allegations to them, giving them an opportunity to respond. All right, so the fifth common workplace issue is out-of-hours conduct. Most of what we just talked about was out-of-hours conduct, but that's out-of-hours conduct where there is a connection to the workplace. Here we're talking about out-of-hours conduct where it's unrelated to the workplace, but you can see there that the relevant test is that the employer may be entitled to dismiss an employee for unrelated out-of-hours conduct where the conduct is likely to cause serious damage to the relationship, where the conduct is likely to cause damage to the employer's interest, or again, the conduct is incompatible with the employee's duties as an employee. So this is some of what Lewis was touching on when he talked about that decision of Rose and Telstra. For out-of-hours conduct, you're saying, well, the first question is, are we able to regulate that behaviour? So is there a connection to the workplace? Did the subject matter relate to work? So that was some of the issues we looked at earlier. Disparaging your employer. Well, that's obviously connected to the workplace because the subject matter was relevant to work. Bullying and harassing a colleague. Again, obviously there's a connection to the workplace. If there's no connection to the workplace, you then kind of have to fall back on, is there some reputational damage to the business? Where the employer's identity can be readily identified in the post, so that is where the Facebook page, the person says who they work for, or their Twitter account or something like that, is that conduct likely to cause serious damage to the employment relationship? So that is, what reputational damage is there going to be? It will depend how broadly the post is viewed. And there's some examples here. So we have two examples. The first one relates to Meriton, and this involved an employee of Meriton commenting on a post that Clementine Ford put on Facebook, and the employee decided to disparage Clementine Ford by commenting on a post that she put on Facebook. Clementine Ford then went to his Facebook page, very quickly was able to see that his employer was Meriton, and decided to send an email or a Facebook post to Meriton alerting them to the fact that their employee was using offensive language and really disparaging someone on social media, to the effect of, "Hi Meriton, are you aware that your employee named Joe Bloggs is doing this online?" Because Clementine Ford has a fairly large following, it was the subject of newspaper articles, and there was a fair bit of media attention about this particular situation, and that resulted in Meriton writing back saying, "Thank you for bringing this to our attention. This employee now no longer works for us." So the employee's employment was terminated for that. So that's a scenario where there was really no connection to the workplace at all. It had nothing to do with Meriton, nothing to do with their employees, other than the fact that this guy's Facebook page identified him as an employee there. And that, again, is an increase. There's an increasing trend of victims fighting back, if you like, and using the internet and social media to find out the identity of people, find out where they work, and alert their employer to the behaviour. And where there's a reputational, where there's exposure to reputational damage there, then the employers will more and more be prepared to act on it. Now, whether or not that dismissal by Meriton of their employee was fair or unfair remains to be seen. As far as I can see, there was no unfair dismissal case, so it wasn't tested through the courts. If it was, maybe the Fair Work Commission would have found that it was unfair to terminate that particular individual. The second scenario relates to SBS and a journalist who was employed with SBS, Scott McIntyre. On Australia Day last year, I think, he decided to send a few tweets out about Australia Day and the fact that it was Invasion Day. Again, there was a huge amount of media attention. I think actually Malcolm Turnbull was the person who alerted SBS to these tweets, and subsequently Scott McIntyre lost his job. He then brought an adverse action claim, and it was set down for hearing in April this year, but I think a week before the hearing the matter was settled, presumably with SBS paying an amount of money, but it's a confidential settlement. But there's some examples of where there is a real risk of reputational damage to the employer for out-of-hours unrelated conduct, and examples where the employer has taken action. A really recent, another case study which I think was finalised last week or the week before, this involved a man from the Central Coast of New South Wales who wrote some offensive things on Nova Peris's Facebook page. Nova Peris then reported him to the police, and he was charged with, I think, threatening someone over a carriage service. So it's actually, there's criminal legislation there, and it's a crime. And last week, I think he was sentenced to an eight-month suspended sentence. So that really shows that where this kind of offensive, unlawful conduct is occurring online, the police do take it seriously, and you know, in some cases it's a criminal offence. Now, this type of conduct can really does have, can have devastating reputational impacts on a business. And this particular individual's criminal lawyer at the sentencing hearing made the comment that his chiropractic business had become a shadow of what it once was. So the media attention that came out of that meant that his chiropractic customers just decided to go elsewhere.
So next we're going to talk about confidentiality and privacy issues related to social media usage. And this is something that is going to become more and more of an issue as we see employees more commonly take to social media and the rise of information distribution online and things like that. The reality is that it's very important for many businesses to keep confidential a number of business and trade affairs, internal secrets, things like that, client lists, customer lists, and the difficulty is that as that information more and more ends up in software and things like that, or in documents that can flow over email, social media more and more can become a tool whereby some of this stuff is divulged. So it's not just email that we're now concerned about, it's about things that people might say on social media that end up giving rise to a breach of confidentiality. Now, a simple example, and one which we've got over Leaf, I believe, and I'm just going to move to the next slide, relates to, sorry, we've just gone one slide too far, so we'll bring us back, relates to a tweet by a midwife in New Zealand. Now, I don't know if that's the actual photo of the baby or that's just one that Kyle's found and brought up. I suspect it's the latter, but effectively a midwife in New Zealand went and posted about a baby who was born and gave some details regarding the weight. Now, not being a parent myself, I'm not sure if 15 pounds, is that right?
Huge
15
baby.
pounds, yeah. 15 pounds, that's big. I'm being told that's big. Kyle's twice the size. Kyle's recently had a baby of his own, so he'd be well aware. Now, that's actually a pretty innocuous post when you think about it. But what it has done is actually tweet a fair bit of confidential and sensitive health information relating to another person, talking about that other person's weight, their name, things like that. And that's actually confidential information, personal sensitive health information. Now, the midwife probably wasn't thinking at all in relation to breaching any obligations, nor thinking about what the outcome of her conduct may have been. And I have to confess, I'm not too sure what the ultimate outcome occurred there. Certainly in Australia, if that had occurred, I'm not sure we would necessarily see in the first instance a successful dismissal, one that couldn't be challenged in the Fair Work Commission, just because I imagine a case could pretty quickly be mounted regarding the innocuous nature of the post and the innocent intent. But the reality is that employers need to be very careful, and this is one of the points of having a social media policy as well, is to educate people about these things. But the reality is that the confidentiality obligations people have, there's no excuse just because you're using a different platform. And so it's about managers being vigilant to ensure employees understand their obligations, and ensuring that appropriate monitoring and reminders are in place so as to prevent information inadvertently leaking into these new kind of forums. So that's something we just need to be conscious of. The other thing about social media that's worth bearing in mind is its now use or utility as a recruitment tool. Now we need to be very careful about this, because people sometimes get all up in arms when you start talking about looking at social media sites before job interviews and things like that. You may well hear from time to time people say, oh, you can't look at someone's Facebook page or their LinkedIn page or things like that before a job interview because they haven't consented to you doing that. It's not actually, I don't agree with that, and it's not actually that simple. The reality is that there is certain information in the public domain that's out there available for about prospective employees. As a recruitment, someone involved in recruitment, if you're there looking to recruit a particular individual, I have no issue with looking at what they may post or looking at what their history is on LinkedIn and those kind of things. The difficulty you start to face and the areas of problems that might arise is if you start to allow irrelevant considerations influence your decision. So if someone posts some religious beliefs that they have or political opinions they have on Facebook, you read that, you form an adverse view about that, and you ultimately choose not to employ someone because of those religious or political beliefs. You may find yourself in a circumstance where you are discriminating against them based upon prohibited or grounds prohibited by the legislation. But that's a measure of restraint that needs to be imposed on you as someone involved in recruitment to ensure that those irrelevant considerations don't influence you. But I think in business and in a commercial matter, you'd almost be, I won't put as high as to say naive, but you almost wouldn't be as comprehensive as you can be if you're not looking at these open forums to try and get a picture about the person you're going to try and bring on board. Now, again, it depends on the nature of the organisation you're in. In the public sector, there's a much more rigorous rules-based recruitment and promotion regulations that have almost a points-based scoring system in order to determine who should and shouldn't be offered a job. And in that scenario, looking at social media may really not assist you at all and may only seek to cause you to deviate from the established course. But if we put that public sector employment to one side, if you're in the private sector and you're in a small business looking to see whether someone's going to be a good fit in your business, I think it's entirely legitimate to be looking at social media to try and get a handle on what a candidate might be like. So you just need to be conscious, though, of those discrimination and adverse action type risks that are noted on the slide there. Now, I think I'm going to hand over to Kyle shortly, but before we do, there's some information here regarding an actual provider of recruitment services based on social media, and so there's a company there referred to called Social Index, which collects data from social media profiles to determine whether someone's a good cultural fit. Employers can then utilize the services of Social Index to try and gain more information about this particular person. So there's actually businesses now springing up that can help you to undertake these types of activities. The next thing that I'd like to talk about before we recap just relates to a question that's come up. Well, it's actually more of a comment now that I'm looking on it. Someone's just posted that they think it's fair to check someone's Facebook profile prior to the hiring process to make sure the candidate reflects the spirit and behaviour that the company is looking for. Well, that's just a comment, but it's one I would actually endorse, provided that your definition of spirit and behaviour is not one that starts to leak into discriminatory grounds, such as discrimination by reason of race, culture, things like that. But if you're talking about spirit and behaviour, about positive values that you're looking for in your organisation, that's entirely fine. just to recap, the reality is that it is legitimate and reasonable to regulate an employer's out-of-hours conduct. We've said that at length. What we're looking for there is behaviour that's likely to damage the employer in some way, and I think that's a message that we've hammered home throughout. A final word on social media policies. I believe that these are a pivotal and very important resource for an employer for this reason. Where you end up in a circumstance where an employee engages in some conduct that the employee doesn't know that it was that bad, doesn't know it's inappropriate, maybe they knew it was inappropriate but not the extent to which it was inappropriate, it's very easy for an employee to plead ignorance. And that has happened in numerous cases. I mentioned the Linfox one from 2010, which was just one example, where the absence of the social media policy was held against the employer and was actually relied upon by the Fair Work Commission to make a finding that in the circumstances a dismissal was harsh, unjust or unreasonable because the employer hadn't appropriately set the boundaries of workplace conduct. So it's very important to have these policies so that employees are educated and an employer can then rely upon the policy if they want to take disciplinary action. Now that point that I've made is effectively falls under the sword category that we've got there in the slide. There is also the shield category, which is it's also just a helpful defensive mechanism to ensure that an employer does protect the information that you have in your business, so that employees ensure that client information is dealt with sensitively. If you take the Centrelink example, so that customers and clients aren't offended, etc., etc., it protects your business. So that's all I'd like to say on that. I think Kyle's going to go into some of the content of these policies. I just want to underline their importance, and that particularly if you're going to end up taking disciplinary action, really critical to have one of these in place.
Yeah, absolutely. And we've got a case study here, which is actually a different Linfox case, a more recent one. Lewis referred to a 2010 case, but there was a 2014 Linfox case which went to the full bench of the Fair Work Commission. And so in this case, Linfox decided that it would implement a social media policy, and one of their employees decided that, or formed the view that the policy impinged on his right to free speech. He didn't like the policy, and so he refused to sign it. Linfox gave this particular employee a number of opportunities to sign the policy and directed him to sign the policy. He continually refused, and ultimately his employment came to an end. So he was dismissed because he refused to sign the social media policy. And it went to the full bench of the Fair Work Commission, and the full bench said that the establishment of a social media policy is clearly a legitimate exercise in acting to protect the reputation and security of a business. So if there was any ambiguity, it now should be very clear that employers are entitled, and it is a legitimate thing for them to do, to implement a social media policy, and employees should be expected, provided the content of that social media policy is reasonable, employees should be expected to sign it and can be expected to. In terms of social media policies and what they should contain, we've got some points here about what social media policies should have in them. Firstly, you should probably define what social media is. It helps so that everyone knows what you're talking about. You should set out what behaviour online is appropriate and what behaviour is not appropriate. Set out the risks associated with using social media, so explain to your workforce why it is that inappropriate behaviour on social media is not acceptable. For example, you might damage the reputation of the business. You should always set out the consequences for a breach of a policy, so that would be, if you breach this policy, you may be subjected to disciplinary action up to and including termination of your employment. It's not sufficient merely to have a policy in place. You should circulate it, make sure employees actually know that it exists. We do see from time to time employers saying, oh yes, we do have a policy. Where is it? Oh, it's put in a folder in the HR manager's office. Do employees know about it? They should. Did you give it to them? I can't remember. You actually have to circulate the policy. Give it to them. I can't remember. You actually have to circulate the policy. As the Linfox case, what happened there was that the employees were actually asked to sign it. So that's not necessary. You don't always have to do that, But if you do get employees to sign it, you actually then have evidence that they received it, they understood it, and they signed to say that they will comply with it. In addition to actually circulating the policy, it's a good idea to then provide training on the policy. If you can do that, then when you actually want to use that policy to justify terminating someone's employment, you're in a much better position. All right, so that concludes the slides in relation to social media in the workplace. We do, just in finalising the webinar today, we do have an offer for webinar participants that if you do have a social media policy, you are able to upload your policy to the link that appears on the slide there, and you'll receive a copy of the slides. You can send through your social media policy, and lawyers at Australian Business Lawyers and Advisors will conduct a quick desktop review of your policy. We'll then send you an email giving you a ranking out of 5 of your policy so that you can see how it matches up with standards. If you don't currently have a social media policy, feel free to contact us and we can have a discussion about whether you should have a policy or not, and if so, what your policy
Thanks, Kyle and Lewis.
should
We've
look
covered
like.
a lot of interesting and useful information today that I'm sure our listeners will take away and implement. And thank you to everyone for participating. I will be in touch later this week with a link to the webinar on demand and information on the great complimentary offer proposed by Kyle, which you can access via the link on the screen. Thank you both again, and thank you everyone for participating.
Thank you.
Thanks.